Friends, this session we will consider the fundamentals of Contract Act. The Contract Act is very much important because it deals with the any transactions between customer and the bank. Mind it well that we will not go to the post marketing or post marketing of or dissection of each and every word in the definition. Frankly, frankly speaking, we are all working in the bank. So mind it well that whatever the proposal is made, consideration for that proposal or agreement is a legal agreement which is provide or made it as per laws. So don't think otherwise. We will only read consider definitions of and then in simple terms what will be the exact nature of that definition we will consider in the practical case. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of the other to such act or abstinence, he is said to be made proposal. Now we will not define or explain each and every word on that. This is just as when customer gives in the bank, he may inquiry, then he will say, I have got deposit. Then you say that this is our scheme, these are the offer, acceptance, and promises and agreement. That may be the oral or by consent. So this is the offer. In contract, there must be a proposal, there must be acceptance of proposal for consideration. And if all these three aspects has been fulfilled, and if it is put in, then it says the agreement. That turns out to be agreement. Here what? This is the offer. Now, what offer means? If there is an advertisement of your bank, you are opening a branch at certain places. Then this is the offer of that peoples of that vicinity that there is a branch or there is a office which is ready to offer the banking services and facilities to public at a large. It is not necessary if you when you put up bank's board on a premises and starts the branch or any offices, that is implied offer, that is the implied offer. It is not necessary that you will contact each and every resident and give a offer in writing that we will provide you banking services, we will give you these services, all that done. If you do it, that is the aspect of the marketing, not as per the law. Just as when any premises, if there is a board of tailor, then that is the offer to the public in general that you come here, I will stitch your suit or what is your cloth. That that is when customer goes there, give his cloth and measurement, he stitches it, return his cloth. Then then this is the totally fulfillment of what you say the promise and offer consideration. So mind it well. When person to whom the proposal is made, significance is assent thereto to the proposal is said to be accepted. The proposal when accepted become promise. What in real terms? You open a branch office. When customer comes, he say that I want to open saving account. You give him second saving account form. He filled it up. You and you take it back. He pays some amount in cash, and you say that your account is open and your account number is so and so and so. This transaction is called, that is the promise proposal, that converted into promise. When you give the in the application form, it is conversion of promise. He fulfill it, then he has accepted your promise, and that. So promisor, promisee, and consideration. These are the three words. Promisor is the person making the proposal. In this case, in deposit account or advances account, vice versa. Bank may be the promisor or customer may be the promisor. Promisee, person accepting the proposal. Either of the two, when accept the proposal, he become promisee. When you approach the customer and say that you keep 5 lakhs with us, we will give a special interest of 8.5%. In this case, you are the promisor. When that customer accept this and give you a check of 5 lakh of rupees and say, put it with FDR or whatever your scheme is there, then in that case, what happened? That person is promising. Then consideration. At the desire of the promisor, the promisee or any other person has done, abstain for doing, or does, or abstaining from doing, or promises to do, or abstaining from doing something, such act or abstinence, promise is called consideration. In our simple case, you say that you give us the 5 lakhs of rupees, we will pay 8 8.5% interest. That paying 8.5% interest is consideration. It is in that simple form. Agreement. Every promises and set of promises form the consideration for each other as an agreement. In in this case, what is the consideration? Money. Bank want to increase their deposit, so they approach, customer fulfill that, giving you the check, and both the and you are agreed to pay 8.5%. That is the agreement. You give the FDR receipt or what is acknowledgement, in which form of, depending on product you give. That is the it is agreement in real term. It is not necessary that each and every transaction should be documented. There should be a documentation and it should be registered with agency. The simple giving FDR receipt is agreement. Promisee, which from the consideration or part of the consideration for each other, are called reciprocal promises. What are the reciprocal promises? You put up at 5 lakhs of rupees, we will pay you 8.5% interest as per customer desire, monthly, quarterly, half yearly, yearly, or after accumulation. Agreement not enforceable by law is said to be void. The agreement, any agreement, which can't be enforced by law, is called a void agreement. You may say there are very much cases of voidable and void agreements, but in our discussion, we will not stress much part on this, because in bank, where where there are very less chances of void agreements. Agreements may be void if bank give any loan and documents are executed by the minor. Then it's a void agreement in simple words. So we're not going to, because we are not going to take minor as a principal debtor and sanction him loan. So let us forget it, concentrate on other real aspect. An agreement enforceable by law is contract. Mind with, every contract is not agreement, but every agreement is a contract, is a maxim. Every agreement is a contract is maxim. On that one sentence, entire contract act has been built up. Any contract should pass through three stages. Earlier stage, communication of proposal. It may be oral, verbal, or in written. Acceptance of proposal. We say that customer, orally we say, you keep 5 lakhs of rupees, which he expected, nodded, give his check, you deposited in that, give him receipt, that proposal is accepted. Then revocation of proposal. When it can be revoked? He said that you say that I will offer you 8.5% of interest on this period. Then you came to the branch. Suddenly you receive HO circular or RBI directive. The maximum interest payable on any deposit should not be more than 7%. Then you have to approach that person and revoke the earlier proposal, saying sorry or by all means that we are not able to fulfill our promise. That is called revocation. Revocation has got, in real term, revocations, but proposal. Your your proposal in this case. So notice means it should not be in writing every time. Orally you can give. Then lapses of time prescribed in proposal. If you say, the customer say, uh, I will give you a 50 lakhs of deposit within 4 days. Okay. That time, considering your demand and time liability position, you say that I will quote you the special rate. Say X. If the person did not pay or deposit a 50 lakh of rupees within that 4 days, then the proposal lacks the time which has been given. It is the failure on part of that customer to fulfill, so it can be revoked. Then another way, customer unable to pay, take like that is the first case. Another case, suddenly within 2 3 days, your DTL position has very much improved, and your bank feels that paying such higher interest is not advisable because we have received so much money in our CASA account. So inability of to accept that proposal is called also revocation. So revocation may be on both sides, not on the single party. Or in this case, that death or insanity of the proposal in our case possible only the proposal is from customer side, not from the bank side, because death and insanity from bank side is impossible. It is not possible. So On customer side, it can be reward. Then acceptance. Every proposal should have been accepted and it should be unqualified. There should not be any qualification while you will uh, proposal is accepted. Proposal should be accepted in total. There may be some proposal which can be accepted conditionally. There are some proposal which can be accepted conditionally, but not every proposal. Then there are procedures to be followed in performing act or process of acceptance. In tender, say we take a case of tender. There is a proposal to society at large and calling tender. Then there is specific procedure to be followed. The tenderer has to submit his tender within specified date. He has to tender as per condition the money along with the tender. He has to submit all the information which has been called in the tender as a documentary evidence along with the tender. So this is the for acceptance, this is the express acceptance. And when it is accepted by performing condition, what performing condition? When your tender is accepted, that agency will give you in writing that your proposal or tender has been accepted. Now, what are the as per tender terms? We have to perform as per the terms and condition of the tender. That is acceptance by performing condition. If there is on tender condition that this road construction should be completed within 6 months, then you have to complete this within 6 months. That is the performing condition. These are offer, acceptance, and performance. In our case, two cases. Customer comes with us with deposit, we accept deposit. That is one thing. Another, you go to the customer and say that we want your account, we'll sanction you such and such a such facility. They are the other cases. In all these curves, inbuilt, these three stages has to be completed and it has completed. In banking case, all our purposes are legal, all our considerations are legal, our institution is illegal, customer is legal. So other condition which can may consider that the condition is violable, it should fulfill so much conditions. It is not in our case. There are so many conditions, ifs and buts in each and every stage. At a stage of promises, a stage of consideration, a stage of acceptance, and a stage of performance. But will not consider or discuss all these in at this session as you are a aspirant for promotion, and what will be discussed will be in lieu of your day-to-day work and for promotion or your knowledge for your practical work. That it is restricted to that aspect only. Agency, what is agency? A person appointed, employed to do any act for another or represent in dealing with third person. The person for whom act is done or represented is called principal. and the person who is representing is called agent. You will observe that branch head in earlier days, who is the branch head, we used to call him a branch agent. He is the agent of that branch. Now we call the nomenclature has been changed as a manager. But earlier that and manager is same, who is manages, but it is the agent. How they that person who is in charge of your branch is agent. He may be employee or must be employee, but in the eyes of third person, when he approaches that person, what is his feeling? I am approaching to the bank. That is the feeling. And what this person who is means manager is representing, I am a branch manager of bank. Means he is standing, he stand in shoes of the bank. Understood? So agency is just like as a working of branch manager for the bank or employee of the bank. Employee is representing bank. Same way, in case this bank is the principal person and we are all employees or agents in respect to third party. When you deal with the third party, mind it well, you are representing the bank. So whatever you say, truthfully, unlawfully, or what is that, it is the impact of bank images because he sees bank is representing him. You are the agent. This is the contract of agency. One stands in the shoes of the principal. It's a agency. Then person who is doing this is called agent. Who can be act as a agent? In you may observe in your day to life also. If any customer is requiring loan, he don't send he come personally at the very first stage of any unit. He said some employees to you for your inquiry. Then he sent his agent. It is not that uh, every time he should give the authority letter or like that. He is acting as that is the act called the implied act. That called the implied act. And if there is any specific some person may approach you with letter that I am the agent of this. I want to do this such business with you or transact with you. Then that expressing letter is also can be there. That is the express agent. The person of age of majority and of sound mind can be appointed as agent. That this is the simple consideration, not necessarily. What the agent and you and agent and principal, if there is a consideration, you need not to inquire and find out. It is not at all necessary. Agent's authority may be implied or express. What I say. Branch manager's authority is the express authority. He has got some delegated power. But if some other one is say that I will do this thing, he may not have the express authority. But if you observe that he is doing such thing, then it is the implied authority or implied agent. He is implied agent. We we used to observe that we say someone to book air ticket or in a, and he gives you ticket sitting in his office. He is not the expressly agent of that air company, but by implied, he is doing the agency work. Then agent is the act of his sub-agent. If the agent to whom you are dealing and his employees are there or he appointed sub-agent, then he is responsible for act of sub-agent. One will take the one simple example. The 10-kilometer metro rail track to be constructed. It is not possible for that company to at a time take the 10-kilometer construction. So it subdivides and put his agent for the construction for each kilometer. If there is any defect or deficiency or bad performance of any of these 10 out of 10 agent, then the principal agent is responsible for that. It is this simple way you can understand the relations of agency and agent. Agent always act on behalf of principal. If any act is beyond his delegated authority, then that act requires the ratification, and ratification should be from principal. In our parlance, we say a branch manager honor one check for exceeding his delegated power. He will consider simple. Then what he can do? He will approach competent or appropriate authority and he get it ratified. His act that I have honored this check, which is not within the power. In what circumstances he has passed the check and all that, and he gets sanction from appropriate authority. Once he get sanction from that appropriate authority, it presumes that his act has been ratified. And this ratification should be complete, not the part thereof. Means that sanctioning authority can't say that. Let a simple example. If 50,000 is the sanction limit, the customer has passed a 75,000 check, account is overdrawn by 25,000. He has a approach authority. Then authority has to ratify the entire act to honor that up to 75%. Authority can't say that I am allowing you to withdraw up to 60,000 rupees, 15,000 is your responsibility. No, ratification should be in fulfilled, not in the part. This is the simple examination. And for ratification also require the true and fair information regarding all transactions. Then, if any unauthorized act has been done by third person, it cannot be ratified. It cannot be ratified third person. It is some concept of ultra-virus and intra-virus act. But if a third person Some third person doesn't know that he is the agent or person whom representing bank has got how much authority, sanctioning authority. So you can't take action against that third person. For third person, bank as a whole, so the ratification and so what you can say after that, the agency may be terminated. In business transaction, I am talking about. In banking parallel, there are different ways. I am not talking about the banking parallels. The if agent is act ultra virus and is continually doing so, where ratification becomes impossible, then the termination of agency is the only contract. Who you will observe now in the newspaper, the railway MSCB has given a bill collection or appointed agencies or electricity bill connection, all is that. And it is observed or found that that agent is not depositing with the MSCB the whatever he has made collection, then termination of agency is because the person to whom the person to have a receipt of payment towards MSCB. So MSCB has to accept and he has to take recover whatever from that agent. And at last there should be a termination of agency. This is we heard in the agency in simple parallels. Then there is a contract of indemnity. A contract of indemnity means one party promises to save the other from loss caused to him by conduct of the promisor or any other third person. In our simple way, we take indemnity bond at the time of disease claim. No? Then we say that you give us the indemnity. The person who give indemnity is called indemnifier. The person who holds that indemnity is called holder. In this case, bank is holder of indemnity and person or who is executing indemnity bond is indemnified person. He may be with the third person. Say there is a one death claim in disease claim we say of a family Kulkarni. You have all the fulfill all the forms and you say that we want indemnity bond to be executed. Indemnity bond has been executed by some Joshi. Then Joshi is the promisee. If whatever is happened or bank suffer loss due to the payment of Kulkarni, then it should will be recovered from Joshi. This is the simple transaction of indemnity. Then there are rights also. In indemnifier as rights. When you give the indemnity, then who is holding the indemnity bond can claim for the specific performance. These are the words are actually not related with our day-to-day transaction. These rights of indemnity holder action the damages, costs, all sums, and suit for specific performance are in case of others. It is not in the case of deceased claim. A person who a contract is awarded, suppose A is the company, the contract is awarded to the B for performance of some act or performance, construction, supply material or whatever like that. Then A say that it's okay, we are awarded the contract, but we want indemnity. The C is given the indemnity that if whatever you lost, cost, such, if B does not perform and due to the non-performance, if any loss is there, I will make good the loss. So that is the damages, cost and all sums as included in section 125. Then A is the person. He is in position to recover from B, from C, whatever he has got. But indemnifier, C is the indemnifier. He is giving indemnity. Then after completion or execution or recovery of you means A, C stands in the shoes of A. Then he has got all the rights, whatever the A has got to recover the amount, including the benefit of contract also means profit and all these things. Immediately C pays you your losses, then C stands to in A's foot. So there is a position has been replaced. Then indemnifier has got each and every right as A has got legal recourses and whatever means. So he received that rights and this is called indemnity. Indemnity has got 3%. Here guarantee. In guarantee there are 3%. Indemnity there are only 2%. Indemnifier and indemnity holder. In guarantee a person who guarantee. Normally every loan account we take the guarantee. If principal debtor or is not paid, then I will pay. It is the simple. A bank is giving 10,000 rupees loan to A bank, ask for the guarantee. B come here, execute guarantee bond and say if A didn't pay, I will pay. That is the simple meaning. A contract of guarantee is a contract to perform promises or discharge liability of third person in case of default. This is simple. Contract of guarantee has three inbuilt relations. Who? Principal debtor, in our case, bank, then creditor, to whom we have given money, then surety, means guarantor, and creditor, and guarantor to bank. These are the three mutual promises, sub promises of contract. We can say when some we get the execute the guarantee bond, then these three relation contracts are the incipient in that bond. There are for guarantee, execution of guarantee, debt must be certain and existing. That is main condition. Then there must be distinct promises, oral or written, by surety. mean surety must execute the guarantee bond. In return, in oral, bank don't accept oral guarantee, but in business, the oral guarantee is acceptable. When a one trader supplies the trade to another person, then suppose there is a B, another trader. B trader phone A trader. Oh, you supply this material. I don't have this material at with me. You supply this material to at that place. He didn't pay. I will pay. I will pay. This happens in day-to-day business community. So that is the oral guarantee, and these are essentials of contract. There must be oral guarantee or written guarantee. There must be supply. There must be creditor. Means good must be supplied there to form the relations. That and in all these cases, the principal debtor is principally liable. To whom the in our case, borrower is the principal debtor in banking relation. He is the primary liability. The surety's liability or guarantor's liability is always secondary. And some consideration must be passed. So when we give loan, some money has been trans, transferred to the principal debtor. He is availing facility. So consideration must be passed. In our case, it is always passed. So we in this entire discussion and your solving question in your exam, don't think that consideration has not been passed, whether it is legal or it, it is illegal. No, everything is legal. You take it for granted in solving questions, and in most of the cases, I am telling not the 100%, in most of the cases, in banking transaction also, you assume that it is in legally, all the transactions are legally and enforceable. Now we are see the indemnity and guarantee. There are distinction in between them. The way is same. We can say what the indemnity contract says. If loss is there, I will pay. The same thing the surety say that if there is a loss, I will pay. But in indemnity, there are two parties: only indemnifier on and indemnity holder. Whereas in guarantee, there are three parties, as earlier explained: the borrower, guarantor, and bank or principal creditor, we may say. Then in indemnity, the execution arises only on contingency. Means what was the that as actor? If that doesn't, everything is okay, there is no contingency. But if anything goes wrong, then suppose the in our deceased claim, Mr. Kulkarni, who has presumed to whom you have paid, if the person is himself is from, he is not Kulkarni. He is the one of the member from Kulkarni, and he is not. He don't have any relation with the deceased. So this is called the contingency liability. Then only that liability of bank loss will arise, and you can recover from the indemnifier. Then in contract of surety is not possible. The this is the coexisting or co-extensive contract. You cannot take a surety, means guarantee for the future date. Whatever the date is there, that should be real and in with. And what it provides some security to the principal creditor that this debtor is not paid. I have the another person to whom I can recover my loss or my dues. And in contract of guarantee, the right of sue is available. Means if your borrower fails to pay, you can file a suit for recovery against your debtor as well as suretor. This right is not available in indemnity. When he fulfills his contract, he pays the bank. The basic indemnifier is contingent as he cannot exercise his in, indemnity bond. That are also cases. There are some cases, but we will not discuss that cases here. We will consider only in simple cases our indemnity bond, our disease claim, and in some cases of LC revocable or foreign exchange goods, this type of indemnity is required, and bank can't file a suit also. These are the cases. But in case of guarantee, we can very well file a suit for recovery, and we, in some cases, keeping aside, we can recover entire amount from guarantor or surety. So these are our normal cases. But as there is a contract, so there must be a revocation. Then surety can revoke guarantee, but by giving notice. By notice, he can revoke guarantee. We were facing in some account in some time. We are taking the guarantee of some person. Let us in ongoing process, the account is with you even 10 years, more year, guarantee everything is. After say 12 years, something happened, we receive notice from surety that don't, I am withdrawing my surety to this account. Then what we do? We stop operation account, then maintain status quo, then call borrower, give another guarantor or surety which is acceptable to the bank. We take that fresh documents and we release original surety. In this case, when surety gives the notice to the bank, he is not liable for the future transaction. So he is the giving, if he has given a notice on 31st May, then for all account positions as of 31st May, his surety or guarantee is valid. If there are any transactions after 31st, up to June or anything, he is not liable. It is called a Clayton's case. Withdrawing of security or withdrawing of partner or withdrawing of it will apply the Clayton's case. Then when guarantee is revoked, death of the surety. In death of surety, but it is a contract or agreement, there should not be any contrary clause. Means in that agreement or surety bond, if there is a clause, if surety expired and his legal heirs will also will become a surety or like that. Such if such clause was there, then it can on then by death the surety can't be released. Then surety can be discharged if the condition between the principal debtor and creditor has changed in terms of contract. Suppose in our case we'll take the simple case. We'll we have taken the facility of suppose 50 lakhs. Principal debtor creditor bank has given. Then another 1 lakh of facility is given to that customer. Then don't presume that this surety will be guarantee for your new 1 lakh of rupees. Or you the borrower property is mortgage with you. You have filed a suit for recovery and you have make any OTS or like that anything and release the property. Suppose loan is 1 crore of rupees, you receive 80 lakhs of rupees and you release property. That the terms and condition has been changed. Then for balance of 20 lakhs, surety is discharged from his liability because the original terms and condition has been changed. Or in some cases, if the principal debtor is discharged, then surety is not liable, surety is automatically discharged. You cannot file a suit for recovery on guarantor only. You can file a separate suit on, on guarantor and recover even amount, but at that stage, the original suit with the principal debtor must be alive and you should not have released that principal debtor. Then there are some dealings between the principal debtor and creditor which are not aware or make known to the surety, then guarantee is revoked. Then if creditor does any act, I mean just to say the release of guarantee or selling the mortgage property in and whatever the remedy the surety has got to have the in possession of that mortgage property or like that or any other source, then he is discharged guarantor and is revoked. Or guarantee is obtained by concealment of fact or by fraud or by misrepresenting, then surety also get discharged. This is the contract of surety. Then we will consider the then we'll see a bailment, contract of bailment. The bailment is the delivery of goods by one person to another for some purpose upon a contract that they shall, when a purpose is accomplished by written or otherwise, dispose of according to the direction of the person delivering them. Bailer, person who delivering the goods, and bailee, the person to whom goods deliver. Actual speaking, When we sanction any facility against the hypothecation, it is a- basically the contract of bailment. But in that, the possession of the goods remain with the bailor, and bailee is the legally owner of that goods. There is no actual movement of goods from bailor to bailee, because if we sanction hy- a hypothecation of stock, a facility cash credit, 50, say 5 lakhs, 10 lakhs, whatever the amount is there as per the security. He is not delivering the goods to the bank and directing bank to keep it as when I will repay 10 lakhs rupees, you give back that my good. So hypothecation is basically the contract of bailment where legal ownership is with the bank and possession is with the borrower. He is selling the goods, then continue the cycle of purchase, sale, purchase, sale, purchase, sale, and go on. We have got only the legal possession, means constructive possession, not actual possession. So hypothecation is basically a contract of bailment that for some promise. What promise? I promise is the facility which we have sanctioned to him. And security, what is the security? The goods. This type of facility is available only to movable goods. The item should be movable and distinguishable. These are the two main factors which needs in hypothecation. A immovable property cannot be hypothecated. Mind it well, because while documentation number of times the hypothecation is taken in number of accounts where it is hypothecation is not applicable. Even the hypothecation of property, which is not possible, and that is not the correct documentation. I am quoting this example specifically because on just scrutiny of some documents in some another cooperative bank, a small cooperative bank, where whatever be the facility of loan, whatever may be the security, the documents were hypothecation due. And it is a real. This is not the hearsay. I am our group have witnessed that actual documentation. Then we have suggested various means to solve this problem. So mind it well. Hypothecation is never expressed in any act, any section in contract. It is basically a contract of bailment where possession is with borrower and ownership is with bank or principal creditor, you may say. It must be a contract, implied or expressly. The delivery of goods must change the possession in contract of bailment. But bank is not going for taking possession of every time and delivering at time of sale. So certain clause has been embodied in that contract. But basically it is a contract of bailment. then it must be for specific purpose. What the specific purpose? He requires the working capital limit. That is specific purpose. He needs business for he needs funds for his business. Then it must be a movable good. One cannot hypothecate his house, factory, unmovable atom which is fastened to the earth as a hypothecated. And in contract of bailment, the return after fulfilling the contract, the return should be the specific goods which has been billed. That is the reason that clause has been embodied in this, and bank doesn't take the possession, only the legal ownership is with the bank. And a hypothecation is basically the contract of bailment only. When the possession is changed the hands, then the terms changes and position is also changes. When the goods or substance has been delivered to the principal creditor, in our case say bank, there is a actual delivery, not constructive constructive delivery happen in the hypothecation. Then the bailer become pawner or pledger, and bailey bank become pawnee and pledgee. These are the names, connotations used in the contract of pledge. Then pledge is the separate contract where the goods are in possession of the principal creditor, in actual possession, in actual lock and key of principal creditor, then it is called pledge. So pledge is also called the extended hypothecation. What happened when account goes bad or fail? We approach that dealer and lock his premises. The goods which are hypothecated to us, we lock that. What it means? That hypothecation is converted into pledge. The position differ, rights also differ, and everything is differ. So it is called hypothecation. It's also called extended pledge. Then there are rights always. Bailer has right. Means when he gives you on payment, the bailer or pawner must receive the goods which have pledged to pledge with creditor. And if there is defect in the goods or title of the bailer, then bailment is voidable, because you know that each trader has got the unpaid stock also. It is not that the facility to whom we have sanctioned to the trader, the entire goods are available in that shop or his premises is fully paid. Bank has a ownership of fully paid amount, but not the unpaid amount. If the case is filed, then the creditor, another creditor who is unpaid, has got prior right over the banks. It is called unpaid seller right. It is in sale of good acts. There is a specific provision. The unpaid seller has got right to have the possession of gold source over all the categories. Then this is not then the termination of bailment contract, and we can he has got right the claim compensation for wrongful act of bailing. Suppose in pledge we have taken the say the bags of sugars in our godown, and if we do not maintain the stock with all calamities, we did not insure it against a robbery, or there is some clauses which hampers the quality of that goods, then bailer has full right on payment to receive the compensation or loss from the bailee. So pledge has got different rights. In hypothecation, if there is a flood and there is a loss of goods, that borrower is not in position to claim damages from bank. In pledge, he has right to claim damages from the bank if the goods are in actually and constructively in possession of the bank. Then any profit accrued to the goods associated to the goods pledged to the bank, he has a right to claim that. This will happen in shares only. Pledge of share. Share is always called pledge. Shares are not hypothecated. So, if bonus shares is declared on the shares with bank and he pays the amount, the bank has to give and must give the bonus share to the customer or bailer. Bank is not in position to say that you have pledged us that 1000 shares on payment, take 1000. Whatever the bonus shares accrued due to that 1000, say to 200, 150, 100, that bank has to give to that bailer, and that is the bailer's right. If in case, say, the bank has taken the huge godown on rental and the goods from various customers has been kept in that godown, it is right of bailer that that goods should be kept separately. There should not be mixing of another goods. If there is a consent that you can mix, will give you. It happens in most of the case. It happened in the case of agricultural product. Suppose wheat, sugar, rice, and these items are kept in the godown, rented in the bank. There are every chances of mixing it, and it may be with consent or without consent, but it happens. If it is without consent of the borrower, then bailer can claim from the bank the cost of separation as well as damages for quality variation. make it make it mine. So in normal cases there are flags in Godon. I have not know how much experience you got in pledge of hypothecation group, but I have witnessed that there are some huge godown where under received the goods are kept on behalf of bank, and there are separate compartment of the pledge of goods of various institutions in same under same roof. Bank is paying the maintenance charges for them because bank can't own godown. There are restrictions to purchase immovable property. We have seen in that banking regulation act. So these things happen. But whatever the loss, with consent or without consent, happened or faced by the bailer, the bailee has to make good that. Then when there is a right, there is a liability also. Bailer should bear the cost of transportation in place go down. Means what? If bank takes some goods in our custody, the transportation and other cost should be borne by the bailer. He should inform the bailee if there are any incipient defects in the product which can be surfaced immediately or which can be surfaced after some days or after some period, for which bailee may face or exposed to face some extraordinary risk, that bailer should inform to the bailee, and for that he must repay in addition with the amount the necessary expenses and indemnify the losses, where at the place time we always take the indemnity bond. And what are the incipient defects? There are some chemicals, there are expiry dates or medicines, there are expiry dates that bailer should inform to the bailee that these are the goods, that these dates of this product is expiring on so particular day. Then bailee will be in position to remove that goods before expiry and additional security. Call for additional security, additional goods or whatever may be there, or decreasing drawing power. These are various tools to be operated in the account to recover the amount. Then there are some goods on delivery, it may exploit, especially gas cylinders. On expiry date, they may exploit. So these are the things that bailer should inform bailee, and bailee must take a note of all these things. Then whatever the goods has been taken as a pledge, it must be owned by the bailer. Otherwise, I earlier told you that there are the claims of unpaid seller. So whatever the title is defective, that is the responsibility of the bailer, because one cannot give the better title than what he has. It is a maxim. But there is a this one exception to this maxim, but that is in Negotiable Instrument Act in case of holder in due course, that we'll discuss when we'll discuss NIA. Then on payment, the bailer must take back the goods. Means suppose on 31st January the bailer has paid the amount, bailee has released the goods, then within a reasonable time, seeing considering the quantum of goods, see if there are bulk goods, then say 1 week, 2 week or that. But bailer must take return back that goods. It is not that the funds are returned to the bank and the possession will be remain with the bailee, so that bailee will take care of the goods. It should not be the case. He must take back the goods whatever he has been pledged. These are the rights of bailee. Same thing, where we just consider the rights of bailer. Now bailee has also got right. Bailee has got the right of, specifically right, in case of banker, he has got particularly as well as particularly. Otherwise, in other private cases, that was the general link. On payment, the goods should be returned. But banker has got the specific right as a particular link. So, if there are dues in another account in another case, and bank feel that we should not release these goods, then he can exercise this right and keep that goods as security for other another accounts. Same way, the bailee has got right to know the faults in the good. If there is a proportionate mix, then claim from share in goods mix. What was the share? Just bailer has got right, opposite bailee has got right. Claim expenses of bailment, claim losses due to the defective title, mean unpaid seller right and all these, or any manufacturing defect on any defect in that product. That suppose you know earlier that some automobile company has got manufacturing defect in some car models, that surface after 1 hour, 1 year or 1.5 year, all the production has been taken back from that company. In intermediate period, if such vehicles might have been pledged with the bank for security, then expenses and deterioration in the assets of pledge of defective title or defective goods, bank bailee has the right to claim damages, and for that bailee has got right to by suit only. Then bailee has got duty. Bailee must take utmost care of goods bailed to him, So pledge, facility of pledge is not so easy. We have to take, bank has got lot of responsibility. Whatever expenses we incurred on that are recovered from pleasure. But bank should take the precaution as if these are banks good. Bank should not utilize the goods pledged unauthorized. Suppose the cars has been placed to you. The bank should not use either of that car for visit to the another borrower or for personal use or bank use. It should not consume. Means the goods pledged with him. Or if it is found that it has been consumed, then claim. Because we find in some cases that in open ground the goods are pledged, the bailor may use unauthorizedly the goods placed to the bank. So he is by right or legal right can recover the damages. Then duties, whatever he has received as a pledged good, he must return that goods. Unless he wish to exercise it particularly. He must give whatever the increase or profit in it. In case of share, whatever the bonus shares is acquired on shares pledge, the bank must give that added share to the. Then some goods there may be increase. I can witness this in if the livestock is pledged. Otherwise, there are very chances for increasing in the goods. In case of shares, okay, if delivery that company has declared a dividend or as a bonus share, but in other cases, if livestock is pledged, then only there are chances of increasing security. For wrongful act of the bailee, he must pay damages to the bailiff. He has taken the goods under pledge and he has not constructed a roof. So, is the if there is a deterioration in the quality due to the sun heat or rain or any other thing, then bailey's duty to pay the compensation. Then lege has got right in default also. If the borrower did not pay, means pledgor did not pay the amount, then this security he has got right to possession and right to sale, giving due notice without intervention of court. He has to give notice to the pledgor that if you do not mean demand notice, just like our demand notice, we should make with a demand with pledgor and can sell directly without intervention of. or he can, on non-payment, create another charge on security, that security for performance, to another institution also, because now it is the owned by pledgee. When he can sell, means he has got absolute power. He can utilize, utilize his power either way and retain the possession against even pledge right is above all rights. Even it is of the government debt also. It is over and above administration also. If your borrower goes into company or borrower become bankrupt and administrator is appointed, bank has got the first charge over that administration charge, mandatory. So we have discussed the normal charges or normal facilities granted to the borrower. Will take break at this stage, and next stage we will consider what are the facilities, rights and obligations available in respect of immovable property. Whatever we have discussed, it was for movable property. For immovable properties, we will discuss within few minutes. Thank you.